3,142 lives were lost due to distracted driving in 2020. And while losing employees is every company's worst nightmare, the risk does not stop there. The fleet vehicles that are leaving your company to drive to and from the job site can carry employees, equipment, and materials that can all be lost in the event of a distracted driving accident, and could even cause injury to people, property, or other vehicles. Distracted driving and working is a topic that MRCA Safety Committee thought important to add to this year's webinar education. Today, we are lucky enough to have MRCA's knowledgeable legal counsel, Mr. Gary Aumann of Aumann, Mahan, and Fury, to dive into the rabbit hole that is distracted driving and distracted working. Gary, as always, we thank you for taking the time to be here today and for always pushing us to do better when it comes to safety. With that, I will turn it over to you.
Okay, thanks, Morgan. Good afternoon, everyone. And I first will apologize because for some reason you can hear me, but I cannot hear Morgan. So I'm going to be rolling here. If you have questions as I proceed, please either email them or text them to Morgan, or use the chat function on the program screen, and then she will text your questions to me. I do want to answer any questions you may have, and you can do that as I go through my presentation and or at the end, because there will be a question slide at the very end. So this is the second in our safety certification webinar series. And this particular section is on distracted driving and distracted working. This is becoming a hot button for OSHA, especially the distracted driving portion, as we'll see as we get through the material. It is an important area, and it is governed under the OSHA General Duty Clause. Now, Morgan, I've lost my ability to forward my slides all of a sudden. This is crazy. Morgan, can you advance my slides for me, please? Never mind, I got it. Okay. I'll tell you, this is going to be an afternoon to remember. So, distracted driving is obviously much broader than just texting while driving. Distracted driving is any activity an employee or you engage in while you are driving your vehicle that could in any way distract you from what you are doing, and that is moving from one place to another in a several ton pickup truck or other vehicle, and have a possibility of causing a serious accident with injuries. So let's just establish that we are talking about not just texting while driving, although I'll explain to you why I make that distinction here in just a minute. So basically, this is enforced under the General Duty Clause. And again, for those of you who've been in the safety area for a long time and who are familiar with OSHA, you are familiar with the General Duty Clause. OSHA establishes the General Duty Clause with regards to avoiding the necessity or using an enforcement mechanism before they have a formal standard. And I'm going to talk about a case I'll be talking about again in May when we start about heat illness prevention, but a case that occurred and actually was decided about a year and 3 months ago, the Sturgill roofing case, as to what one of the judges of the review commission, how they addressed heat illness in that case. But the bigger picture was how the review commission addressed the application that OSHA made of the General Duty Clause. The General Duty Clause is actually part of the Occupational Safety and Health Act, and it covers the 3 points you see on your screen right now. And those 3 points are: recognize hazards which are causing or likely to cause death or serious physical harm. The number 1 point, recognize hazard, is one many people get confused about. It does not have to be a hazard you recognize. but a hazard that either OSHA recognizes and has communicated to you as the employers, number one, or two, a hazard recognized by your industry, and that is the roofing industry, but it sometimes can be more broadly construed as the construction industry as a whole. And then finally, or by your company. Any one of those three will make it a recognized hazard. Causing or likely to cause, and that is something that all OSHA needs literally is one or two cases where they can demonstrate that what they are saying is a recognized hazard has caused death or serious physical harm. And that's how we get to distracted driving. And we get there also because on April 15th of 2014, 8 years ago, just a little over 8 years ago, about 8 years and 11 days ago, OSHA issued a memorandum where it stated that it considers texting while driving a recognized hazard. And therefore, the general duty clause applies to distracted driving or texting while driving. And then OSHA over the years has expanded that to just about any form of distracted driving. Now you think to yourself, well, gee, okay, so distracted driving, I have an employee who was texting on his or her phone as they were going from one job, from the office to the job site, and they were involved in a motor vehicle accident in which they received injuries. And because the injuries were severe enough, they had to be hospitalized. So I had to report it to OSHA because it was something that occurred while they were working, while they were on the clock, even though, and they were going from point A to point B, both of which were work locations, and they're hospitalized for treatment. So I got to report it. OSHA rolls out and they ask to see your distracted driving program. And you say, well, I don't have a distracted driving program, nor do I have rules with regards to texting while driving. And I'll get to it in a future slide, the considerations with regards to texting while driving in particular. And you feel that, okay, cite me for the general duty clause, so what? I'll settle the case, get a lower penalty. You'll take the case, the citation down to an other than serious, so I don't have to post it on ISNet World. I don't have to admit to it whenever I'm doing pre-quals for big roofing jobs like, large manufacturing facilities or large retail establishments like Target stores or Walmart stores or something along those lines. And you find out after the citation has been issued, and you go to the informal conference and you say to the area director, hey, can't we resolve this? I'm willing to pay the full fine if you'll just take this down to an other than serious, because my employee was texting while he or she was driving. And yes, they were distracted, and that did cause the accident. And but I'm prepared to fight this because I do have a policy against texting while driving. And I thought I'd use the unpreventable employee misconduct offense to enforce this. Let's put that off to the side for a minute for purposes today. But all you've got to do, OSHA area director, is take this down to an other than serious, and we've got a deal, and I'm out of your hair. And the OSHA area director looks, she says, I'm sorry, but I cannot reduce this to an other than serious because general duty clause violation, by their very terminology and the word right here in line 3, death or serious physical harm, mandates by law, by statute, that this be a serious violation. Therefore, I cannot reduce this to other than serious. And all of a sudden you are confronted with a situation of either having to pay thousands of dollars to litigate the case, and perhaps you even go so far as to engage an attorney like me or someone else who does OSHA defense work, and they look at the case and find out that you've never enforced your texting while driving program, etc. And there are other things we'll talk about down the road that can be smoking guns in your history. And there's really very little chance we can win the case. And it's going to cost you $25,000 in legal costs minimum to litigate it and defend it. Or you can just roll over and pay the fine and take the serious And for the next 3 years, when you do pre-quals, you'll have to admit you have a serious violation on your record that resulted in the hospitalization of an employee, and you know the rest of that story. So is there no hope? Well, there is some hope, and that is, but only if you have a program that prohibits distracted driving and texting while driving. And that hope comes from this right here. And that is 1926.21B2. Now we have a specific standard. And this standard says the employer shall instruct each employee in the recognition and avoidance of unsafe conditions and the regulations applicable to his work environment to control or eliminate any hazards or other exposure to illness or injury. Now, those are nice words, because what you could point out is, if you've got a program, if you have a policy, and I hope you're picking up on the fact you have to have a policy. But if you have a policy, you will be able to argue to the area director or to the OSHA. Your lawyer will be able to argue to the OSHA lawyer that, look, we have a policy, and maybe we really didn't communicate it effectively, but we have the policy. So perhaps because you have the policy that recognizes texting while driving as a hazard and prohibits our employees from doing that, but maybe we haven't communicated or instructed our employees effectively. So how about this? How about we settle this and you withdraw the general duty clause violation and reissue a other than serious citation for failure to instruct by employees in the policy we have, a recognition and avoidance of unsafe conditions arising out of distracted driving, and our internal regulation prohibiting distracted driving. So if we'll pay you the fine, we'll pay you whatever that fine is. It's up there right now. It's going to be, let's say it's $10,000. We'll pay you. You reclassify this as a 21B2 and eliminate the of the serious to another than serious. And not only do you have that opportunity, but you have these two standards of sections that can also be used to try to negotiate your way out of a general duty clause violation, which for many employers is very, very, very detrimental. And I just was talking to a client, actually a roofing contractor earlier today, who shall remain nameless. And we were talking about this, a similar situation involving a different general duty clause situation. And I mentioned that I just finished negotiating a settlement in a general duty clause case in northern New Jersey, which had led to a fatality for my client. They were cited under the general duty clause. Only it was a case I knew I could win because it was the OSHA screwed up. But my client said, we don't mind going to litigation, but we can't wait for the final decision because most of our big customers are refusing to let us bid work because we have a general duty clause serious violation on our record right now. And as long, even though it's not a final order, we're saying there's no violation there. They're saying because it's there, we cannot let you bid our work. So some companies are actually establishing that. They won't even wait for a final decision. If you have a general duty clause serious violation, it could ace you out of being able to bid work for a long period of time. So these are two other options. One is 20B1, which says it's your responsibility to initiate and maintain such programs as may be necessary to comply with this part. And this part is obviously the general duty clause, the distracted driving program, and the memo by OSHA back in 2014, or B2, which requires frequent and regular inspections of job sites. I'd stay away from that one if you're trying to negotiate and concentrate on the first, the one I just showed you, which is 21B2 or 20B1, and use those as negotiating tools. So we've talked about a little bit about what you can do and how you can operate to try to get out from under a bad situation. But let's talk about how did we get here in the first place? Well, first of all, I ran some numbers when I first got involved in dealing with distracted driving. That goes back to 2014. Actually, before OSHA came out with this memo, I was trying to get my clients to recognize this as a hazard. And this little table I put together says it pretty much says it all. If you are driving 60 miles an hour, in 1 second, you go 88 feet. That means in 5 seconds, you've gone 440 feet, which is about 1.5 football fields. And if you are concentrating on what you are sending, what you are texting, either reading a text message is coming into you or sending a text message, you are going to, you're not going to be aware of what's going on. So, and of course, if you're doing 70 miles an hour, you're even going farther. You're going almost 2 full football fields. And even at 35 miles an hour in 5 seconds, you're going almost the length of a football field. And a lot of things can happen. And you ask yourself, well, this is not going to happen to me. This can't happen to me. And I could spend the next 40 minutes doing nothing but giving you examples of cases that I'm aware of in which an employer ended up getting, and not only, this is before OSHA got involved, and some since OSHA, but where the employer got sued by an injured person or an injured party because the employer's employee was texting while driving, and in one case ran into a school bus loaded with kids. In another case, hit 2 people in a crosswalk. In another case, rear-ended at a traffic light, a car that was legally stopped at the traffic light because the person driving the second car, the company, actually it was a company pickup truck, hard to deny that, had the company name on the doors, and ran in, rear-ended the vehicle stopped at the traffic light with 3 people in it. Surprise, surprise, all 3 people had whiplash or neck strains. One person claimed a herniated disc in their neck, which required surgery. And you can imagine how excited the insurance company was to have to pay those claims off or to settle them, because there was very little they could do to defend those when the person was clearly texting. And by the way, if you're sitting there thinking, well, they only know he or she was texting if they admit they were texting. Good lawyers now do it's basically called electronic discovery. And what they do is they issue, as soon as the plaintiff's lawyer, as soon as they, and I'm not sure where everybody's from, but I know Morgan is aware of the TV ads we see in the Dayton area for various plaintiffs firms all over the state of Ohio, Elk and Hockman and Plunkett, and all these different plaintiffs firms that are just waiting and advertising. One guy says, if you're injured, dial HURT. And recently I was in San Antonio and I wasn't even aware. I was just listening to had the TV turned on as background noise. My wife and I were down there for one of my trade association meetings. And here's a guy running an ad, and basically it's a plaintiff's law firm. It says, if you get hurt, dial 444-4444. And I thought, gee, that's a strange number. I get back to Dayton, Ohio, and for some, watching Jeopardy or something at night. And what comes on but another guy from our location, same number. And then I did a little research and found out this is a national consortium of plaintiffs' attorneys. The point is they're out there, they're looking for clients. And so that sort of thing sticks in a person's mind. So those 3 ladies that got hurt in the car that was rear-ended by it wasn't a roofing contractor, by the construction company's pickup truck, because the person in the truck, what the first thing was when the first lady went to and hired a lawyer, which occurred like 2 days after the accident, the first thing the lawyer did was got an order from the court, filed a complaint, and then got an order from the court, which basically told the defendant company that all cell phones, all electronic communications, including cell phones, emails, text messages, etc., had to be frozen. Nothing was allowed to be deleted under penalty of a contempt order by the court, because this was a court order, which happens all the time nowadays. So the communication was locked down. So the company couldn't get out from under this. So this speed issue here is the main reason we have causing or likelihood of death or serious physical harm. And like I said, these things are happening more and more. So what, from an OSHA, let's get back to OSHA for a minute. And here's what OSHA will say, why, when, and if they decide you don't have, or you do have a general duty clause violation. Again, I will tell you right now, I'm working on 8 construction industry OSHA cases right as we sit here today. They all were inspections, none of them distracted driving, some of them because of other injuries where my client had to call in the injury to OSHA, and OSHA came out to the job site, did their inspection. In other cases, they were just employee complaint inspections that brought OSHA out to a job site. But in all 8 of those cases, in not one of them did they ask to see the company's distracted driving program. So this has not yet gotten to the point, as we'll find out on May the 10th when we talk about heat illness, this has not yet gotten to the point of heat illness prevention. OSHA is not typically coming out to job sites asking to see your distracted driving program. I'm not saying they won't. In your case, if you happen to have an OSHA inspection next month, that the compliance officer won't ask to see it, because as long as they have probable cause to come out and do the inspection, they can ask for any written program you're required to have, and you're required to have this kind of a program. I doubt if they will. So here are the 4 things that will give rise to it. Number 1, you do not have a policy that prohibits texting while driving. So if you don't have a written policy, it has to be in writing. As I love to tell groups I speak to, as well as my clients, as far as OSHA is concerned, if it's not in writing, it didn't happen. It's got to be in writing. Number 2, you require your employees to text while driving. Your roofing contractor, let's say a component of your business is residential roofing, and you do require your salespeople when they're going out to talk to Gary Allman and his wife about putting a new roof on their house. Well, as soon as if you get the job, if you get Gary signed up, then I want you to go over to Morgan's house and see if because she called us and asked for a quote, and give her a quote. And by the way, don't forget to check your emails, your text messages, etc., before you leave at the end of the day. And no, you don't get overtime. You're going to have to get all this done during the day. And so Gary figures out that the only time he can get this done is while he's driving from Allman's house to Arwood's house. So are you requiring me to text while driving? Indirectly, you are. Indirectly, you are requiring me to text while driving. And of course, this takes you to the 3rd point. You create incentives to text while driving. Not an incentive that says, hey, Gary, if you can do, for every text message you send while you're driving from point A to point B, I'm going to reward you with $50 added to your paycheck. No, that's not what we're talking about. The incentive is created by saying, hey, Gary, if you can get 10 new roofing jobs before the end of the week, you're going to get a $500 bonus. And now it's Thursday, and I've got 6 jobs, and I've got 8 more hot prospects. And if I can get 4 of them signed up by tomorrow, close of business Friday, I'm going to get a $500 bonus. So essentially, you have, because of what you've done there, you've created an incentive for me to text while driving, because you pretty much say this has got to be done during the working day. Depends on the language you put with the incentive program. You created a situation which incentivizes me for texting while I'm driving, which essentially sets up an OSHA general duty clause violation. And then finally, number 4, and it ties 2 and 3 into number 4, your corporate structure of work expectations so that texting while driving is a practical necessity. And this can happen with your foreman or superintendents or anybody like that. I have one roofing contractor I've worked with has a person that goes around and checks all residential jobs. That's what they do all day long. And while they're doing that, They will be getting text messages and sending text messages and or emails. It's pretty much the same thing in the business context of things. They're getting emails and text messages to which they need to respond, and they've got to do it. So what happens? They say, I'm not going to do it while I'm driving. I'll do the text message while I'm stopped at a traffic light. So they stop at the traffic light and they're texting response to a response. They just read a text message when they stop, and now they're typing in the response. The light turns green and they're still typing. Somebody behind us lays on their horn. Get your butt moving, buddy. Oh my gosh. And then you hit the accelerator and they're still texting as they're moving forward. Well, I'll ease through the intersection as I continue to text. And the next thing you know, there's a guy up ahead of them that was making a right turn into a gas station, and he ran right into the back of his vehicle. Whatever. Those are the situations where your work expectations or your structure tells your employees that you expect them to respond to text messages as they go. This is what OSHA expects you to do. Prohibit texting while driving. OSHA expects that you will have a policy that says no employee of ABC Roofing Company may text while driving. And there are penalties. If we find out you're texting while driving, you will suffer penalty. And then the second thing is you establish work procedures and rules that do not require texting while driving. And in fact, you prohibit texting while driving. Again, with penalty. And this is another one of those areas, if you've ever heard me talk about safety enforcement programs, this is another one of those areas where you have to enforce your work rule consistently and objectively. This is not one where you can ignore it and ignore when it happens. And in fact, you need to, you'll see a little bit later on, you're going to have to find a way to determine and monitor it to ensure that your employees are not texting while they're driving. Number three is you establish clear procedures and times for employees to text safely. That's not as hard as it sounds. You tell any employee that if you're driving from point A to point B and you're going to be on the road for an hour, 30 minutes into your drive, I want you to pull off at a safe parking area, either a gas station or a McDonald's or Burger King or any place like that. Pull into a parking place and boot up your phone and look at your phone and respond to any text messages. And this goes back to something I'll mention a little later. I strongly recommend, and I hope you all understand this, but I strongly recommend to my clients that they have a work rule that requires employees to power off their phone when they power up their vehicle or at work for work purposes. They power up their vehicle, they power off their phone. And you have a program that says every 30 to 45 minutes when you're driving long distance, you pull off into a safe place, turn off your vehicle and power up your phone. Check voicemails, check text messages, check emails, respond to those that you have to respond to, and then proceed on your trip. Incorporate safe communications into your worker orientation. This should be part of your new hire safety orientation program. At ABC Roofing here, we have a distracted driving program. We insist that you not operate your cell phone, smartphone while you are driving. And in fact, number 5, we eliminate any incentives that would encourage texting while driving. So any incentives where you incentivize the employee from never taking a break from communication, and that whatever it might be, and this is something I read that OSHA is suggesting. I'm not sure what kind of programming you would have where you incentivize employees to be in communication every minute of every day. But if you do, then you want to eliminate those kinds of incentives so employees recognize the fact that there are times when they do not have to be in text or email communication with you or anyone else. Emails is not difficult. If the employee has an out of office message, they put on their email and says, hey, I'm driving from point A to point B, and I'm not going to have my phone powered up while I'm driving from point A to point B. So you get this out of office management. I anticipate I'm going to get to point B at 2:15 this afternoon. And at that time, I'll check all emails and all text messages and return everything. That makes sense to me. So that's another issue that's so important with regards to texting while driving, and basically removing incentives that might encourage somebody to text while they drive. But now let's talk about other types of distracted driving. And this is policy. Your policy should address cell phone policy, smartphone policy, should address hands-free versus non-hands-free. So I've got some companies, my clients, say, look, you're allowed to use your phone to communicate verbally while you are driving as long as you do hands-free. Okay, well, the vehicle I currently drive, it's got my phone is Bluetooth through the speaker system. If I have the radio turned on, or if I don't, but I send a text message, if I send a call, I make a call, it automatically cuts off the volume from my radio, and I'm hearing and speaking literally into the dashboard. It's great, but I don't use it anymore, or very seldom do I use it. I don't have completely clean hands, I have to admit. But even hands-free communications does distract the driver from what they're doing. And I can give you a personal example. I've given this, if you participated in the SHARP Elite Contractor Safety Certification Program, and if you don't, I urge you to do so. It's a great certification, a little bit of I'll give you a little more of an advertisement at the end of the presentation, but it is a great program where you've got not only an MRCA SHARP Safety Certification certificate, but you've gone through 6 hours of training, and it is something you can use because you also have to do the safety recognition program. So, and when I respond to distracted driving, when I do my critique letter, I've relayed this to several people I've written the letter to, and I said, myself, I was in Morgan knows the area I'm talking about. I was on Interstate 75, which runs between Dayton, Ohio, and Cincinnati. It's about 54 miles from Dayton to the Ohio-Kentucky, the Ohio River, the Ohio-Kentucky line. And as I was driving to northern Cincinnati, I needed to go to the OSHA area office, which is, let's say it's about maybe mile marker 12. And as I know where I'm at, I'm fine. I'm in the fast lane, fast lane. I'm driving along and I get a phone call. And I answer the phone call by verbal command. I never have to take my eyes off the road. I'm able to answer the phone by verbal command. Just say answer. And my client is talking to me, and I'm talking to my client. And they're in the midst of an ongoing OSHA inspection. This isn't critical. This could have waited. I could have told my client, hey, I'm going to be off the road in 5 minutes. I'll call you back. But I didn't. I went on, just continued talking with them. And I'm doing 65 miles an hour, which is the speed limit as you hit north of Cincinnati. And I'm still doing 65 miles an hour and paying attention to the phone call, not paying attention to what's around me, road signs and those sorts of things. And the next thing I know, I have driven right by the Sharon Woods exit, which is the exit I need to take, and I was in the middle lane. And the problem with that is, now fortunately, I didn't realize it until I was already past the exit, and then I edged over, got out, went around, came back, and got off. But had I seen that when I was maybe a half quarter mile from that exit, what's the human reaction at that point? Oh my gosh, there's my exit. We jerked the wheel to the right. Fortunately, that didn't happen because I had an 18-wheeler coming up behind me on the right, and I would have pulled right into his path had I done that. But it made me really think about even hands-free communication, never taking my eyes off the road. My mind was not on where I was or my driving. That's why it's called distracted driving. So my point here is even hands-free driving is distracted driving. Has OSHA gotten around to saying that yet? No. But would you have liability, third-party liability, if somebody who works for you was talking hands-free and caused an accident, or was involved in an accident that arguably was their fault, is that going to get you out of it because they were talking hands-free? No, you are still going to be liable for that accident. So another restriction would be, and that is you may not use either hands-free or non-hands-free in heavy traffic or bad weather. At a very minimum, if you don't want to listen to me and you want to still permit your employees to use hands-free, okay. That's okay, I understand. I'm not giving you permission. That's okay, I understand. But you should then at least say, if you're in heavy traffic or in bad weather, in the midst of a snowstorm, in the midst of a driving rainstorm where you can't see more than 1 or 2 car lengths ahead of you, something like that, then you'd have to shut down your phone. Also, you may answer calls while driving only if you can do it like Gary does it, and that is with only verbal commands. Same thing with placing calls. You can get this. I mean, many vehicles now permit you to have a call list, et cetera, where you can place calls while you're driving. So the last time I did this presentation, somebody raised their hand and said, well, okay, but what about if I don't know the phone number? But if I open my phone up and look at the emails I've got, I can find that client or that customer, and I can find their phone number, and then I can punch it into my phone and make a call. Yeah, but you can't do that while you're driving. You can't do all those things. I don't know of a phone yet that will let you verbally pull up a message, an email message, and then verbally, without ever looking at your phone or the message, get the phone number that's in the signature block of the message. So unless you can do all those things, you should not be placing calls while you're driving to unknown numbers. And the same with responding, only respond if you can do so without taking your eyes off the road. And as I mentioned, number one, the liability issue, third-party lawsuits, biggie. Depends on who you hit, how badly your employee was at fault. And when I say you, I'm talking about your employees as to the third-party lawsuit issue. This is another biggie. You can make a traditional non-workers' compensation situation into a workers' comp situation. First of all, understand that we have 50 states. The workers' compensation laws in each state is unique to the state. In Ohio, if you are commuting to work and you are involved in an accident, your injuries are not compensable. I believe it's Iowa. I had a case 10 years ago where I was just advising, because I don't do workers' comp outside of Ohio, but I was advising a client there who had an employee who was driving back he was heading home from the office, and he had an epileptic seizure. And as he had this seizure, he jerked his pickup truck, which was a company pickup truck, that had nothing to do with this, it turned out, and rolled it and suffered severe injuries. In Iowa, that was compensable, because when he talked to me, I said, in Ohio, that's not compensable, but you should have your insurance company check to see what it is in Iowa. And he said, my insurance company told me that is compensable. Even commuting incidents are compensable in Iowa. But take another situation where the employee has been home. He's at home, he's a salesperson, or he's a superintendent or somebody in an upper management, field management position. And he's going out to pick up a pizza for his family and bring it home to have for dinner. And his phone rings, and next thing you know, he's on the phone because it's a customer calling, or the foreman of one of his crews is calling with a problem to talk over. So he carries on that conversation and ends up in an accident. Arguably, in any state, that's going to make that a compensable workers' compensation claim. And even though it's caused by the fact that the person was engaged, was on their own time essentially, but they were engaged in work-related business, and it takes you back up here to the lawsuit. And because even though he's on his own time, he's doing work for you that he believes you expect that he will do, it's going to make your company liable for the damages, including personal injuries in that lawsuit. And then, like I said, both of these are enhanced with the new OSHA policy on general duty clause citations, etc. So what about other forms of distracted driving? These are other things that you should prohibit your employees from doing while driving. I know we've all done it. Well, maybe not all of you have done it. I've not done personal grooming, I can say, although I've been behind men who have an electric razor and are shaving in the morning as I'm coming to the office. They're driving right ahead of me or next to me, and they're using the electric razor to shave. I've not done that. Have I done eating? Oh yeah. I've gone through a drive-through, got myself a cheeseburger or something. Usually I stop when I come out, I fold the paper back so I can handle it with one hand. I put a straw in my drink, and then I've done this. I don't do it anymore. And I can see, I can picture myself driving down the interstate, burger in my left hand, right hand on the steering wheel, and now I want to get a drink from my Coke. What do? I raise my leg and start cheering with my knees and grab the Coke. These were my younger days. And this is before OSHA got pretty much onto this sort of thing, but I literally did that. I don't do it anymore. I haven't done it for many years, but I still see people doing it. Drinking, same thing, especially hot drinks. You all remember those McDonald's lawsuit of 20 years ago, where the person got a couple $1 million from McDonald's because they spilled a cup of hot McDonald's coffee on their groin and suffered serious burns. They weren't in an accident, fortunately, but hot drinks, the same thing can happen and result in an accident. Personal grooming, I've talked about. Smoking. Now, in some states like Ohio, if you're in a company vehicle, you're not permitted to smoke. That's against the law in Ohio now. It has been for several years. You know, you can't smoke in businesses. You have to go outside at least 50 feet away from the entrance to the business, and you're not allowed to smoke in company vehicles. That would include crew cab trucks and things like that. But again, picture the person's driving down the road and he's got a cigarette, and as he's driving, he bumps a cigarette, and the burning ember on the end, I've never had one because I don't smoke, but I've seen the burning end of the cigarette. We all have. It flips down onto his pants or her dress, and it's burning a hole in the fabric, and sooner or later it's going to be burning a hole on their leg. So what's a natural reaction? As soon as that flips down and you realize what happened, you look where to go. Oh, there it is. And what are you taking there? How long does it take you to look away from driving, look down on your pants, find out, see the ember laying there, and start brushing to get rid of it? Where are your eyes when all this is going on? Unless you've got 4 eyes, or you can split them, have one, the left eye going down the road and the right eye moving around looking. They're now on your pants or your dress, or they're watching it, so that you're flipping it onto the floorboard of the car or the truck. That's distracted. In those 5 seconds on an interstate highway doing 70 miles an hour, you just covered 2 football fields in that 5 seconds. Somebody changed lanes ahead of you, whether they did it properly or not, you didn't see them. You weren't paying attention to them. And then reading while driving, and that's the other thing I've done in many years ago, although not to the extent I've seen people doing it. I've spent a lot of time on the roads going to workers' comp hearings, and probably once a week as I'm going to a hearing, I see somebody driving down the interstate and look over as I'm passing them, and there the driver is with a newspaper over his steering wheel, reading the newspaper as he or she is driving down the road. That is also distracted driving. And what does this extend to? Is it limited just to motor vehicles, cars? Not necessarily. It can be any kind of thing, and even though this is distracted working, distracted driving applies to forklifts and scissors lifts, aerial lifts. Those are also operating power equipment that requires you to drive it. That's distracted driving. It's also distracted working. We're going to slip over into that for the last 10 minutes or so of this webinar. And distracted working is almost the same thing as distracted driving. And again, you know, you say to yourself, well, there comes Alman, he's an old prude, he's just trying to eliminate anybody from being able to do anything while they're at work. No, I'm not. I'm not trying to do that. What I'm trying to do is eliminate the likelihood of an accident. Now, what I've got here, we come down here to this bullet right here, working on any elevated area. I have defended an OSHA case. I won't even tell you where. Let's just say it's an OSHA case. And fortunately, we got a good result. We didn't get it vacated, we got a good result because we had an employee who was on the roof. It's a roofing case, he's on the roof, flat, low slope roof, flat roof. We were using warning lines and a safety monitor. and an employee is working inside the warning line. He's a fairly young man. He's just left the Marine Corps. He has a significant other who's in London, England. He's, of course, back here in the United States. Now he's out of the Marines, still heavily involved with the young lady in London. He gets on a phone call with her on the job site. I don't know. We've never determined whether he called her or she called him, but he gets involved in a fairly, how should I say it, animated is a good word, animated conversation with her, to the extent that he's walking around the room. Think about it. How many of us have gotten into an animated conversation, maybe in your backyard, wherever, and you find sometimes instead of standing in one place, you feel better, you're more comfortable walking around. Well, that's what he was doing. Only he was in this animated conversation, not paying attention to where he was or where he was going. And he walked right through the opening in the warning line and ended up going to an area of the roof that they weren't working on yet, and stepped on a skylight, went down through the skylight onto the floor of the facility, 25 feet, concrete floor, basically crushed his pelvis. My client had to call it in, and OSHA came rolling out. General duty clause violation for, again, first of all, they cited us for not having a competent person on the job site. I'm going to quickly go back and so I can get you all exactly what they did. Here we go. Oops, here we are. They cited us under 20B2 here. They said we didn't provide for frequent and regular inspections by a competent person. The argument was if you had a competent person on that job site, he would have been aware of what this young man was doing, would have stopped him from doing it. And they cited us under 20B1 and said you had not had a program prohibiting talking on a cell phone while you're working on the roof. And they cited us, in addition to that, for not having an effective safety monitor. Why didn't the safety monitor stop him when they saw him leaving? And the safety monitor said, well, I yelled out at him, but he wasn't paying attention to me, and there's no way I could have caught him before he stepped into the skylight. So all of those things were like the perfect storm. Everything came together, and this young man ended up in the hospital for a long period of time, seriously injured. And we managed to negotiate a very good resolution of this. We ended up with no serious violations because of what he was doing. And the OSHA area director understood that, and we ended up with several other than serious. It cost the company quite a few $1,000s in fines, but we got out from under without any serious violations on the record. But as I told him, I said, I wouldn't count on this happening every time. If this happens again, you're probably going to get repeats, and it's not going to be a pretty situation. But they never cited us under the general duty clause for distracted working. So what I'm talking about here under distracted working is maybe it's the future as far as a general duty clause citation, but you can get cited for it now under those standards I just referred to, 20B2, 21B1, 21B2. You can get cited under those standards today if you have people who are not necessarily violating an OSHA citation, but they're acting in a hazardous manner that is exposing them and others to a hazard. And OSHA's on the job site, you could get cited for their observations of that kind of activity. So you should, again, I recommend prohibiting smartphones on the active area of the job site. And when, again, I'm grading the safety applications and I get to that, we haven't had that on the 2021 application, but we'll have it again. And when I grade that application, if the company doesn't have a program where they prohibit employees from having a smartphone on an active work area, we have a problem. And what I tell them is, you tell the employee you can bring your smartphone to work with you, but you leave it in your vehicle or put it in the gang box. And when we take breaks, you can get your phone and we check messages, return phone calls during the 15-minute or 20-minute morning break, lunch break, or afternoon break. And of course, as we'll find out next month, if we're in a high heat index environment and you're taking a cooling off area break under a work rest regimen, you might have access to it even more frequently, maybe every hour, and you can return phone calls, but you won't have it with you. Because one other thing I've seen happen, and that is where a person with a phone on their hip or in a pocket gets a text message, and even though they've got the phone on vibrate, that vibration alerts them something's coming in. So they drop what they've got, reach in their pocket, reach in the holster they've got, pull it up, and are looking at it as they're walking. And no matter how many times you tell somebody not to send a text message while they're on the job, they're going to forget that because it's from their wife. Hey, honey, what time are you going to be home for dinner? And he figures, well, she needs to know now because of what she wants to cook, so I better let her know now. And they forget that rule and they immediately start typing in a text response. Those kinds of things are normal human reactions, and you have got to insert yourself between your employee and the normal reaction. And the best way to do that is eliminate having smartphones on the job site in the active work area. The active work area. Your roofing contractors, the active work area is typically going to be the roof. Yes, it might be down on the ground too, where you're doing housekeeping stuff, but on the roof is the active work area I'm worried about. And you just prohibit phones. Maybe just say on active work areas for the roof, something along those lines. And this is the same thing applies if the person's you have a sheet metal shop, person's operating machine, a press brake, manual press brake, and I'd say probably 50% of the press brakes I have seen in my career, I've seen a couple hundred of them, about 50% of them had no guarding. And there's an argument that you don't need a guarding. But if a person's on a smartphone, carrying on a conversation while they're operating the press brake, and again, they lose sight of where they are and what they're doing, next thing you know, they're taking off a fingertip or something. Walking around a construction site, scaffold, working on scaffolds, same thing as working on the roof itself. Distracted working also includes reading and horseplay. I think most of us have work rules that prohibit horseplay. Maybe not thinking of it as distracted working, but it is. And reading, of course, is the same thing as we've been talking about. Hazard recognition, and this ties into distracted working, or distracted working ties into hazard recognition. What's another thing I always ask when we ask the question about hazard recognition, what's your program to train employees on hazard recognition? The very first thing I'm looking for in response to that is we have a distracted working program. We prohibit employees from doing anything that will distract them from their work area because they should be aware of that work environment 24/7. And what I mean by that is they're on the work site for 10 hours, 60 minutes in an hour. For those 600 minutes, they need to devote 100% of their attention to their work environment. They need to be sensitive to sight pictures and sound pictures. And you can't do that if you're reading text messages or talking on a smartphone, even if you got a Bluetooth set up. You can't do that. You're going to be distracted. You're not going to be paying, and you're not going to be paying attention to changes in the sight picture or the sound envelope that might indicate a hazard entering the work area. A hazard entering the work area. And that is what's so important. I'm on a scaffold. I know that most roofing contractors don't use a lot of scaffolds, if any. But suppose I'm on a scaffold on the side of a building, and all of a sudden I hear this growling, rumbling noise that something is entering this work area, and it's obviously a piece of heavy powered equipment. I need to look around to see what it is and where it's headed, because, yeah, my scaffold's barricaded off, but if this guy's driving a big skid steer or something like that, and he may not be in a position, or she may not be in a position to really observe the scaffold or the fact that I'm on the scaffold, and all they've got to do is clip it and knock it down, and I'm in trouble. So those kinds of things are so important so I can take defensive action if needed to protect myself. Rules on the above issues have to apply to everyone, including management at all levels. When employees telephone or text at work, you confirm where the communication is originating from. And I am saying yes to enforce the program until you get your employees to take it seriously. Maybe you want to do a 90-day introductory rule. And during that 90 days, you send some text messages to employees that you know are driving their vehicle and just see if they respond. And you can give them a friendly warning during that period of time. You know, this rule goes into effect on, let's say, July the 1st of this year. And when this rule's in effect, if you take a text message from me or anybody else, and we can tell that you took it, and we know you're driving, you're going to be subject to progressive discipline. But you need rules on have to apply to everybody, including management. This is another area where management needs to set an example for all employees. And when calling an employee or texting them, confirm where they are if they answer the call. So I require that you have your phone powered off while you're driving. I call your phone and you answer the call. Hey, where are you, Morgan? Where are you? Well, I go, oops, I guess I better be parked. Shouldn't have, I shouldn't have answered the call. My phone should be powered off. Try it, give them some lead time to get used to the program, and require communication providers app on all company phones to control the ability to text while driving. And you can get apps, although I cannot give you information on it myself, but I have had clients who told me there are apps out there that basically tie into the system with the car that basically make it impossible to text message while the car is in motion or while it's powered up. The same thing goes with even speaking. If your employees put a voicemail or a out of office message on their phone that says, I'm sorry, I'm engaged in driving a long distance for the employer right now. I'll be stopping every 60 minutes to check on the voicemail message, and I will return calls at that time before I start driving again, but I will not be able to take your call at this time. Thank you very much. Boom, that's it. And then we follow through with that. And Morgan, that's it. So since I can't hear you, if you got any text messages, why don't you let me know? We're just about out of time. Okay, you got it, kiddo. Wait a minute, I got 3 chat messages. Hold on a second. Okay, hold on, Morgan, before you take it over. I just now see I wasn't looking at the chats myself. I got a chat from someone that says, commuting to work in Iowa is compensable, ? 10 years ago, it was compensable. That example I gave you was about 10 years ago. Like I said, I don't do workers' comp defense out of the state of Ohio, but this client just called me. It was under a legal services plan like we have with the MRCA, and it was not the MRCA, actually it was an installation contractor. And he asked me that question, and I said, look, I can't tell you what the law is in Ohio, in Iowa, but I can tell you what it is in Ohio. And so he checked with the insurance carrier, and the insurance carrier came back and said, yep, it's compensable in Iowa. I said, okay. I said, if I were you, I don't think it should be. I said, my conversation was, I don't think it should be. If I were you, I'd call my attorney and spend $50 and have my attorney check the Iowa workers' comp law to confirm that. I didn't believe it at the time, but this company didn't want to cross swords with the insurance company. They said, okay, we'll just, you take it. If it's yours, okay. And I said, okay, I think you're making a mistake because you're going to see it in your premiums. They said, well, I don't want to have to make a mountain out of a molehill. And the other question from the same person was, what about using a GPS from phones? You can, if your GPS, it's no different than the GPS if you have it built into your dashboard, as long as you're not watching the map and you're just taking verbal directions from the GPS that are coming over the speakers or I wear a hearing aid, so I have a Bluetooth for my hearing aids. I get my directions told me as I'm driving through my hearing aids. So I can, I can handle it that way. So I got one new message, and the question here is, who can see your messages recording on? I'm not sure about this one. This is Stephen. Stephen, I'm not sure what you mean by this. Who can see your messages? I'll tell you what, one other quickie before Morgan takes over. One other quickie here. If you are on this call and you have any questions for me, just email me or text me. You have the legal services plan. You get a half an hour of my time free at no cost to you each month. And today is the 26th of April. So if you have questions about this presentation, it's perfect. Email me your question or call me, 937-673-4602. Your call will probably go to voicemail, but I check my messages immediately and I'll return your call. And again, that's under the legal services plan. So I can answer your questions verbally, one-on-one, or by email, where I'll be talking with you individually by email or on the phone. So don't fail to take advantage of that. And of course, that's every month, but right now you can use you've only got 4 days to use your 30 minutes for the month of April. This is a perfect opportunity for you to use it if you have a question and you want a more detailed response than I could give you. Now, Morgan, I'm shutting up.
Okay, everybody. All right, awesome. Thank you, Gary, for presenting today on distracted driving and working. As Gary mentioned, one of the great benefits of membership with MRCA is our legal services plan that entitles you to get 30 minutes of Mr. Almond's time each month you are a member with MRCA. We have information about how to utilize this confidential membership benefit on our website, mrca.org, or feel free to reach out to me for his contact information. And we will make sure that when we send out the recording and presentation of this webinar that you guys get Gary's contact information. Just a few quick housekeeping items before we sign off today. First, for anyone that is viewing this webinar post-recording, you will need to email me the code word to get credit for your attendance today. Today's code word is roofing 2022. That's roofing 2022. So just email that to me. It's mrwood@mrca.org, or you can find me on our website again, mrca.org, and I'll make sure that you receive credit today for attending. Next is a super exciting announcement, and hopefully you've already heard, but this year, the Roofing Contractors Association of Texas and MRCA will be partnering for a gigantic trade show in beautiful Fort Worth, Texas. Make sure to be there and save the dates of September 27th through the 29th for RCAT and MRCA's joint conference and expo. That's September